Please be seated, everyone, and thank you for joining us this morning. We have 3 cases set for oral argument today, and we are going to begin with the case of State versus Medina. And I believe Mr. Smith will be arguing for Mr. Medina.
Thank you, Your Honor. May it please the court, opposing counsel. A rule really only means something if there aren't so many exceptions to the rule that it can be bypassed at any time. And a right only means something if there are costs to it that we still have to enforce, even if there are some things that we would rather have not happen when we enforce that right. The right to a jury trial imposes costs on a society, and the right to confrontation also imposes costs on society. In this case, what we had was an 18-year-old, an adult, who became an adult during the trial, who was allowed to give testimony.
Facts a little bit more close to the line. When you say she testified, the day before she also testified and she was 17.
That's correct.
You're talking about the second day, less than 24 hours later, she testified when she was 18.
Yes, absolutely, Your Honor. I didn't mean to imply otherwise. So she testified when she was 18, after she turned 18, and the court found that they would still allow closed circuit testimony even though she had turned 18. They did that on the basis of her mental illnesses, and the court found that she would suffer some trauma if she were to continue to testify without the aid of the closed circuit. This court and the United States Supreme Court have never allowed such an exception to the Confrontation Clause, and it should not allow it now.
The trial transcript, and I didn't see that trial counsel raised a confrontation objection when they came back the second day. I thought the argument was centered solely on whether the statutory requirements have been met. Am I misreading it?
I think that you are, Your Honor. I think that it was based on the initial hearing. She'd also made a Confrontation Clause argument, and that she was also making a Confrontation Clause argument on that day of trial.
I mean, the problem is if counsel had made a confrontation argument specific to what you're making now and said, well, you know, once someone turns 18, there's no video exception to face-to-face confrontation. Maybe the trial judge would have said, okay, we'll do it that way. I mean, it might have agreed, or something else might have. Why, you know, it seems to me unfair that to now ask for a new trial based on something that wasn't sought at the time.
An error preservation issue, Your Honor, and I think the state has conceded that error has been preserved on that issue. I think that both at the time that they had the hearing, there was an objection based on Confrontation Clause, and at the trial, there was an objection based on the Confrontation Clause. Now, there wasn't an objection based on the Iowa Constitution or anything, so that's not preserved, but you can always exercise your independent state judgment to decide that perhaps this does violate the Iowa Constitution.
On that point, then, if we're only looking at federal, Maryland versus Craig, is that our governing case?
Honor.
I don't think it has any particular age. I think it just says child.
I think it does say child, but we have to have a determination between child and adult. At some point, how the Supreme Court and this court has always sort of viewed it in other circumstances is when it turns 18. We do that in the juvenile sentencing scheme, for example. That's how the statute defines a child, someone under the age of 18. I think that you know, if the child has a definition at all, it has to be someone under the age of 18.
That the chief was making earlier, is it true, just looking at the transcript here, that the testimony would have gone into the second day with this witness for maybe an hour?
There's actually a significant cross-examination period. There's not timestamps on the transcript, so I can't say exactly how long, but she was definitely cross-examined more on the second day than she was on the first day. So I don't think that the state can claim that this was harmless error and that she was sufficiently cross-examined.
Sure that the transcript at the beginning and end, but was direct done on day one?
Direct was done on the
start on day one, and it continued into the next day, and everyone knew it was her birthday? I assume?
I think that everyone knew, maybe the court didn't know, or people weren't keeping track, but defense counsel definitely knew, and so did the prosecutor, that she was turning 18 the next day.
Turn to this question that Justice Mansfield raised about the nature of the challenge. So I know in the district court, defense counsel acknowledged Maryland versus Craig, but as I read the argument, it was that those factors had not been satisfied on the facts of this case. So he says, or trial counsel says, so I would ask that the court find that the state has not met the established requirements under Maryland versus Craig and as contained in State versus Richards, and it goes on, but there's really not a challenge to the statutory scheme. It's really just a fact-finding contest, as I understood the district court challenge. Correct me if I'm wrong.
Fact-finding contest, but also a fact-finding contest in the context of Maryland v. Craig. There are certain factors that have to be met under Maryland v. Craig. Say a child, it has to interfere with the child's ability to communicate, to testify. So I think those fact-finding challenges happen in both the statutory context and in the constitutional context. In addition, I still don't think that there is sufficient evidence that the child or the adult, if we're talking about the second day of trial, could not reasonably communicate. There was nothing that they said that they could not communicate. The focus was almost solely on the harm that they would undergo. That ability to communicate is an important part of the analysis under the Confrontation Clause.
Specific finding on the communication?
The judge did make that, but I don't think the record supports it. The GAL, sorry.
Testify about the risk of a freeze or flight situation. I mean, the jury found that the defendant had abused her for all those years, and she's diagnosed with having post-traumatic stress. Why isn't that sufficient evidence to support the finding?
Testimony by the victim that said that she couldn't testify, she was going to have that freeze or flight response, that the already sufficient safeguards that we have in a courtroom wouldn't be enough.
So at trial have cross-examined her about that?
Whether there's
a hearing, if it was one sought on that issue?
On the state to prove this, that there was no violation of the Confrontation Clause. So I don't think that defense counsel has to necessarily question about that. But the evidence that I saw was that there's no statement from her. That with no statement from her, I don't think the court.
It has to. You're calling her the child in one day and the next day she's an adult. But you're saying that witness has to personally testify about how traumatic testifying would be, and that the expert's testimony based on her relationship is not solid?
An evidentiary finding that based upon the treatment and that has happened, that this person cannot communicate more than just that this would be traumatic for them. It would be traumatic for almost all victims of crime in almost all circumstances. I mean, right now, this.
Let's say you don't have to have the witness implode on the stand to prove that they would implode on the stand.
I mean, yeah, you can find that beforehand that they were not going to be able to communicate, but I don't think that this record supports it. But I mean, I'm sorry.
Fine to agree that this rule applies only to children, child witnesses. Is this the right case to make that determination, given that she was a child legally on the first day of her testimony, and through incredibly unusual circumstances, she turns 18 on the second day? Maybe we just say, look, at the time she started testifying, she was a child, and that's sufficient to satisfy the constitutional rule.
No, I don't think so. I think you have to go against. It's unlikely you'll ever find this case again where they turn 18 during this time.
Circumstances. I'm thinking, and I know they completely revamped the code section numbers, so you're going to see how old I am. I'm going to use the old numbers. But 232.26 sub, all of those subs, one of them has to do with when you can terminate the parental rights of a child, and it has to do with, has a child been, if the child is 6 months of age or younger and has been removed, blah, blah. There have been cases where a child during the trial is going to change ages, and there are cases out there that say on the day the trial starts, that's the magic number. Couldn't we analyze that similarly?
So I think that the exception to the confrontation clause, especially because there's a new finding in this case. So there's a new finding that happens on the day that she turns 18, adjusting this to,
Judge hit all those buzzwords from 915.38 sub 1 sub C about witness with a mental illness, intellectual disability, or other developmental disability, regardless of the age. Didn't he hit some of those?
some of those words. I don't think that that satisfies the confrontation clause, there needs to be a necessity finding. And so the court has talked about what those necessities are before. Efficiency, things like that, those aren't necessities. Protecting a child, a witness that can't communicate, the court's found that to be a necessity. Essentially, if you ruled in this case that there was no error, you're saying that, okay, that's a new necessity that we have. And so the confrontation clause becomes that much weaker, becomes so degraded at that point that we can really have non-direct, non-face-to-face testimony in a wide variety of criminal cases. Well, because right now it's almost exclusively limited to child sex abuse cases. This could really open up the floodgates, so then we have this in robbery cases, we have this in assault cases, we have this in a lot more cases. Right now we have a lot more of these hearings.
That the testimony on the first day was okay?
The record supports it. I still don't think that there was any evidence that the child couldn't communicate. And I think that that is a very important determination under the Confrontation Clause of Maryland v. Craig.
Testimony on that from a counselor and a GAL. Do we have to give some deference to the credibility call of the judge in hearing that testimony?
The Confrontation Clause, the court will review this de novo as a constitutional issue. So I don't think that any deference needs to be given.
De novo review, we can give weight to the credibility findings of the trial judge who was there in person with the witnesses, right?
Have to. I don't think that you're constrained in that way.
How you're so dismissive of the expert's testimony. I'm looking at some of the things that he or she, I can't remember if it's a man or woman, testified to. On the second day of testimony, the district judge reviewed his previous ruling, which would be the 18-year-old testimony, which I personally cannot imagine changed much, but he reviewed his prior testimony and concluded that because she'd been diagnosed with PTSD, anxiety, depression, had had 2 inpatient hospitalizations, because of those things, she could continue to testify via closed circuit, and in quotes, again, as the court previously held with her minor age, it's more than discomfort because of the presence of him, and she would suffer, obviously, significant stress, and it would make it difficult for her to communicate. How is that not evidence in your mind that is strong and worthy of consideration by the court?
I mean, it's worthy of consideration by the court, and I don't mean to be dismissive. I'm saying that these are costs that we have of having a right to confrontation. And without that finding that even if it's traumatic, they also have to not be able to communicate. I think both of those things have to be met in order to hit those Craig factors. Otherwise, it's not a necessity that can justify not enforcing the Confrontation Clause. Other than what we're looking at in terms of how widespread this could be and how often we could be having closed-circuit testimony in a wide variety of criminal cases, the Confrontation Clause really doesn't even, if you look at the text of it, say that we're going to look at this only happens in necessary cases or reasonable cases. It says all criminal prosecutions. In all criminal prosecutions, you have the right to, and so those necessities should be very, very carefully and narrowly drawn. It should not be a case of, well, we want to protect this witness. It's going to be traumatic. A lot of times it's going to be traumatic. Those are the costs of having a right in any society.
Up differently. I mean, there's reference that it's one way, and other cases talk about 2-way. How did it work here?
It's not super clear from the record, but I don't think it really matters in terms of the decision, right? They'd already said that it was okay, and I think that that was the error in this case. Instead, she should have had to testify in face-to-face confrontation. Seeing that my time is almost up, I'm going to retire unless I have any further questions. Thank you.
May it please the court, I'm appearing for the state today for the purposes of oral argument only. There are two separate issues in this case. One is, did we satisfy the requirements of Iowa Code Section 915.38? And secondly, did we satisfy the requirements of the Sixth Amendment? We'll start first with the statutory law. So Iowa Code Section 915.38 permits a child, a minor, a person under 18, to testify by closed-circuit television. I would say that in this case, the record establishes that it was one-way closed-circuit television, not two-way. And on the first day, I think the appellant concedes that KD satisfied the requirements of that code section. The question is whether she similarly satisfied the requirements of the code section on the second day. In Iowa, we typically, especially when it comes to juveniles, we look at them we look at their age at the time when it starts. So if she was 17 at the time when trial started, we wouldn't typically then not treat her as a juvenile if she turned 18 in the middle of the trial. There are lots of good reasons for that, as some of the reasons the court have pointed out. Like, she was the same child on the second day as she was on the first day. There was no change in her.
To be clear, if this were the O.J. Simpson trial and somebody started out at 17 at the beginning and then months and months later, and let's say they had their birthday after the first day and they continued to testify for months at different periods throughout that as an 18-year-old, your position would be that because they were 17 on the very first day, that's the end of the story?
That is what the legislature intended. It's not reasonable to assume that the legislature thought we would stop in the middle of a trial and change the proceedings.
Was there any evidence that the court, even after day one, seemed to be nearing the end, entertained, hey, let's keep going. Let's get this person finished. She's 18 tomorrow. Was that any part of the record, or is that any consideration that could have happened?
There's nothing in the record that indicates that happened. If you look at the record, you can see that this case was continued a number of times. There was a mistrial. There were some efforts by the state to kind of push this forward. People were clearly aware that this was an issue that could arise. And on the second day, when the prosecutor was addressing the court, she did point out that there had been some delays the day before, which she at least attributed to the defense in terms of taking time to review a videotape of LG that could have been done at a different time or could have been done after the hearing. So I think there's a flavor that the prosecutor not necessarily thought there was gamesmanship, but certainly was aware of the problem and was disturbed that this had been allowed to go into the second day.
Courts have said that the Craig case has been undone by the Crawford case, and I think there have been even a few courts that have said that too. How do you respond to that?
The Craig case is clearly, unarguably, still good authority. The Supreme Court has had 20 years, at least, to revisit that decision. It has not done so. As of Monday, it had twice denied cert on issues related to Craig, and I would point out to the court that just yesterday, the U.S. Supreme Court denied cert in a case out of Illinois, which raises the exact issue raised in this case. It's 2023 Westlaw 3910581. The court in Crawford, did not overrule Craig, did not even mention Craig. And really only Justice Scalia is of the opinion that face-to-face confrontation is the essence of the Confrontation Clause. And he has never persuaded a majority of the U.S. Supreme Court. Neither have lower courts in general found that persuasive. Craig and Crawford just address two different situations and apply two different tests as a result. Craig involved a case where the witness appeared and was subject to cross-examination, and all of the protections of the confrontation clause, save eyeball-to-eyeball confrontation, were there. In those situations, the court has said and consistently found that we can apply a sort of a not categorical test, but a test of whether it was reliable evidence. In Crawford, in contrast, the witness didn't appear at trial, wasn't cross-examined. Most of the traditional concerns of the confrontation clause were presented in Crawford. And in that situation,
explanation of it, but if that's right, why have so many federal circuit courts and federal district courts written about this kind of unresolvable tension between the two cases and the overruling of Roberts, which undercuts the rationale of Craig? I mean, your explanation seems very compelling, but there seem to be a lot of federal judges who disagree with that. Why is that?
Federal judges in the minority or dissents or concurrences who disagree with that. And it is certainly not unusual for there to be debate among lawyers and judges about what the law should be. But there's no debate about what the law is. Craig is good law until the U.S. Supreme Court says otherwise, and it has declined to do so. And because this is the Sixth Amendment issue, the U.S. Supreme Court authority is controlling. But again, sure, looking at it superficially, I think it's, or even with some depth, perhaps, to be fair, it is kind of difficult to reconcile Craig and Crawford. But the court says we must, and there is a reasonable explanation of why they apply it differently.
Does it make a difference whether it's two-way or one-way closed circuit?
The U.S. Supreme Court has not addressed that. Our court has said that two-way testimony by an adult is okay. And most of the lower courts who have looked at it agree with that. And the Gigante case, and that circuit kind of goes off on its own a little bit, but it straight up said where you have two-way communication, that is confrontation. It meets all the requirements of confrontation. Most courts, to be fair, have found that it is not confrontation itself, but that because it is so close to eyeball, forehead-to-forehead confrontation, that it satisfies the confrontation clause.
I want to go back to, you started at the beginning saying that the defendant didn't really dispute that the statute was met on the first day, and it kind of sounded like he did, and at least that's how I took his argument. With respect to kind of the floodgates, and if PTSD is enough, then every victim with PTSD would satisfy this, at least if they're a minor. Could you address that, please?
There is no floodgate to be opened by Iowa Code Section 915.38 because it incorporates the requirements of Craig that there be necessity and that there be at least more than de minimis trauma to the victim tied to this particular defendant.
And I think that the focus on trauma seems to downplay the focus on, that's only one side of it, it's the inability to communicate part of it. How strong does that have to be?
The court hasn't clarified that for us. It says it has to be more, the trauma has to be more than de minimis, and the testifying in the presence of the defendant would render the testimony unreliable or perhaps make it not happen at all. The record here is really strong. So the therapist testified that her concern was that Katie might not be able to testify at all, that she might simply freeze up and be incommunicative. And the guardian ad litem expounded on that. They really felt that there was an issue with being able to really communicate at all, truthfully or not. So the record here is really strong. And keep in mind that this victim was engaging in self-harm behavior. She was removed from the home. She was committed and hospitalized twice. So this is not a situation where there's a factual dispute about whether this victim qualified as a mental illness or as a child who would be traumatized by the presence of the defendant.
With respect to the therapist testimony, I'm not sure what the record reflects, but how much opportunity is given to the defendant to have enough information to cross-examine the therapist? So are there access to treatment records, et cetera? It just seems to me it's a tough case to make when you have a therapist testifying and the defendant's really left with nothing other than trying to poke holes during cross-examination without having access to relevant documents?
Really no record on that. We know that the defendant had the reports. There was some testimony. There's nothing in the record about whether the defendant obtained the medical records. I don't know of any reason why they could not. And typically, I didn't see a request to see the medical records as part of the discovery, so I don't know. But they certainly could make that, and probably that would be granted because the victim witness's medical history would be relevant.
Preservation on specific to once she turned 18, the second day. I read the transcript of the second day of trial. I mean, not second day of trial. Second day that she's on the stand. That the complaining witness is on the stand, and I don't see anything coming out of the defense lawyer's mouth in terms of a constitutional objection to remote testimony once somebody turns 18. It seems to me it's just totally kind of an evidentiary hearing on whether the witness meets the revised requirements that under the different statute that applies in Iowa to witnesses that are over, they're 18 or over. Am I correct about that?
That's what the record says. There is no discussion of the Sixth Amendment on that second day of testimony. The state did concede preservation, presumably because the pretrial motion raised a Sixth Amendment claim, and that was sort of an ongoing discussion. But
they're two separate issues. The one, I mean, the issue that Mr. Smith came in right off the bat was once you turn 18, the Sixth Amendment categorically prohibits remote testimony. And in this case, I don't think the trial judge knew she was going to turn 18. I think it may have been a surprise to just about everyone in the courtroom when that happened.
Honestly, but the court could not conduct a Sixth Amendment analysis on that second day.
And asked to.
Original hearing, was there any discussion then about the fact that she might turn 18 before she was done testifying?
Original motion was filed more than a year before the hearing, and then the hearing was actually held before the first trial that was mistried, and
after that,
a formal hearing after that.
Our court is not bound by the state's concession of air preservation.
The Confrontation Clause does not require, and never has required, that we sacrifice our victims on the altar of face-to-face confrontation. The U.S. Supreme Court has said in Craig that the situation presented here meets Sixth Amendment requirements. There's no compelling reason, factually or legally, to diverge from that approach in this case, and the state asked that the court affirm the conviction in this case.
Mr. Smith.
The United States Supreme Court has never said that we can dispense with face-to-face confrontation for adults. It only can dispense with a confrontation clause if there's a necessity, if public policy dictates it.
For day two, but it was never made, right?
Well, it was made when it was made in the pretrial motion. They said that they violated the confrontation clause. They said that they meet it.
Before the first mistrial, was it ever renewed once there was a mistrial?
They already had ruled on it. And
did the defense make the point that it would apply differently to an adult than a minor?
I think that the defense that was raised was the confrontation clause. It probably was not as specific as the argument I'm making now.
No, was that there was some delay the day before, and her testimony got started late. I mean, the trial judge made a record of that maybe she should have started earlier and probably would have gotten done. I mean, there wasn't, at the time defense counsel was making their motions based on the confrontation clause. She was 17, and it wasn't anticipated she would turn 18, was it?
I don't know if it was anticipated or not, but even regardless of the delay, I don't think the delay changes things or when the trial starts changes things. The confrontation clause is only dispensed with in issues of necessity. And when we have said the necessity, the only thing the Supreme Court in the United States has said before is that it needs to be done for child witnesses. And so I don't think that because when the trial started and then she turned 18, that really changes things.
I'm maybe confused. Aren't you saying the district court didn't actually rule on that distinction?
The district court said that it wasn't going to violate the confrontation clause.
The court wasn't presented with the distinction that you're arguing before us now. The district court didn't rule on the distinction that you're asking us to focus on today, correct?
I don't think that the area of preservation rule is required to be that quite technical.
Okay. So you'd also agree with the state, though, that we aren't bound by any concession by the state as far as error preservation, right?
Well, I've never thought you guys couldn't do whatever you wanted. But I mean, I think that we have an argument. This violates the confrontation clause. Then we have the judge saying, oh, well, it doesn't violate the confrontation clause. I think that is the point of the error preservation rule, and that's sufficient for the court's rule in this case.
The distinction would have been helpful, right? I mean, the whole point, or one big point of the error preservation rule is the district court could have gotten it right at the time. There wouldn't have to be, you hear, years passing, a possibility of a second trial if we went your way, right? So it feels like that the whole point of error preservation was kind of failed here a little bit because it wasn't brought up at the time. And, you know, maybe that'll be brought up down the road, but it's hard for me to say that issue is properly before us.
And parties will always be like less or more specific than the court wants, and rulings will always be more or less specific than the parties will want. I think that as long as he says this violates, Sheila says this violates the confrontation clause, the court says no, it doesn't, I think that's sufficient. Otherwise, there aren't really rules about error preservation. It's like it needs to be this specific, it needs to be this specific. There's some rules about, you know, bringing up Iowa Constitution claims. We understand what we need to do there in order to preserve error, and that, you know, really wasn't preserved in this case. But I don't think that level of specificity is ever really governed by a rule that is specific enough. If the party said this violates the confrontation clause, the court says it doesn't, I think that has to be sufficient. Otherwise, it gets very, very technical, and it gets very, very in the weeds. As long as the parties say this is an issue and the court says it's not an issue, I don't know what else the parties are going to be able to do.
Raise this exact issue for the district court to think about, right?
Well, you know, that would have been helpful. It's not my record. Yeah, I mean, they could have been more specific about it on the day of trial. I will concede that. Looks like my time's almost up, unless anyone else would like to get after me about error preservation.
Get after me. All right. Thank you, Mr. Smith. The case of State versus Medina is hereby submitted.